Human rights are often discussed as values: freedom, dignity, liberty. But in practice, human rights are legal limits on power. They determine what governments can do, and more importantly, what they cannot. In the United Kingdom, many of these limits are shaped by the European Convention on Human Rights. This video explains why the Convention exists, how it operates in everyday governance, and why its role matters even when it is not visible. The European Convention on Human Rights is a legal treaty. It was drafted in the aftermath of widespread state abuse across Europe. Its purpose was not symbolic, it was structural. The Convention establishes minimum standards of treatment that governments agree to respect. It does not replace national law, it operates alongside it, setting boundaries that domestic authorities must account for. The United Kingdom played a central role in drafting the Convention. It was designed as a safeguard against the concentration of unchecked power. Human rights law does not exist to guarantee ideal outcomes. It exists to restrain authority. When governments act, through legislation, policy, or administrative decisions, they exercise power. The Convention requires that power to be exercised within defined limits. It introduces concepts such as proportionality, necessity, justification. These are not moral ideas, they are legal tests. They force decision makers to explain why interference with individual rights is warranted. Without these constraints, authority becomes discretionary. Domestic rights can be amended or repealed. International obligations are harder to dismantle. The Convention functions as an external reference point. It creates a shared legal baseline that does not shift with political cycles. This matters because rights are most vulnerable when they depend on popularity or convenience. International frameworks reduce the risk that protections will erode gradually, unnoticed. They provide continuity. The Convention does not only operate in courts, it influences how public bodies act day to day. Authorities are required to consider rights when making decisions about detention, policing, healthcare, housing, social care, immigration. Often, this consideration prevents harm before it occurs. When the system works, nothing dramatic happens. That invisibility is often mistaken for irrelevance. If a state removes itself from an international human rights framework, protections do not vanish immediately, but the structure changes. Legal limits become internal rather than external. Future governments gain greater flexibility to redefine standards. What was once a legal obligation becomes a policy choice. This does not require malicious intent. It occurs through gradual shifts in priorities. Rights become easier to narrow, easier to suspend, and harder to enforce. Human rights law is not reactive, it is preventative. Its function is to stop harm before it becomes entrenched. By imposing legal boundaries, the Convention reduces the likelihood of systemic abuse. It assumes not bad actors, but imperfect systems. History demonstrates that unchecked authority does not need dramatic moments to expand. It grows quietly, through exceptions and administrative convenience. The European Convention on Human Rights does not promise perfection, it promises restraint. It ensures that power is exercised within limits that do not depend on goodwill. Its importance lies not in high-profile cases, but in everyday governance. When protections work, they are often invisible, but once they are gone, their absence becomes difficult to reverse. Human rights law exists not because governments always act wrongly, but because they are human, and systems without limits eventually overreach.